was still blocking a moving lane of traffic and had struck a school zone signpost. The officer also observed the defendant's motor vehicle had crashed in the direction moving against the flow of traffic, and the witness identified the defendant as the driver. EMS saw the defendant in the driver's seat of the crashed vehicle with her feet sticking out and the engine still running. Upon contact with the defendant, the officer observed bloodshot eyes, slurred speech, and unsteady balance on the defendant's person, along with a strong odor of an alcoholic beverage, and general disorientation and slow responses. When asked about the accident, the defendant stated she may have fallen asleep but did not remember the crash occurring. The defendant admitted to drinking and consuming Adderall, and she said that she was the sole occupant and operator of the motor vehicle. The officers recovered 2 open alcoholic beverage containers from the passenger side floorboard.
Drinking while driving?
Yes, Your Honor. And 4 unopened containers. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 8 out of 8, and 1 leg stand 3 out of 4. A blood warrant was drafted and executed.
And Judge, on the first DWI, the lab results came back as 0.286.
0.026.
0.206, because there's a big difference. Is it 0.26?
Yes, 0.286. Yes, Judge. Yes.
Yes, Your Honor.
That is a very high blood test. Can you run an NCIC? I'd like to know what other kind of criminal history she has, number 1. Number 2, did we have her sign a no driving affidavit on the first one? Because if she did, I'm going to have a contempt hearing.
I don't see a no driving affidavit on the file, Your Honor.
Yeah, well, her driver's license wasn't eligible though on the second DWI.
Probably because of the first and the ALR. Mr. Treadwell, I want you to be perfectly clear about something. I'm going to do everything in my power to protect the citizens of Harris County. Every single day, someone dies because of a DWI in Harris County. And I will do everything in my power to protect my city. And if that means putting you in custody because you repeatedly flaunt our bond conditions, so be it. Now, I'm going to revoke your bond and I'm taking you in. And now, if you do get out, you will have a strict curfew of 7 p.m. to 7 a.m. And I'm forbidding you from going within a car at all. You will now be signing an affidavit, and if I find that you drive, and I don't care what your reason is, I don't care if Jesus comes down and tells you he needs to ride to church, you get into a car and drive, I will have a contempt hearing. Every time you get into a car, it's up to 6 months in jail and a $500 fine. On one ankle, you will get a GPS monitor. On your other ankle, you're going to get a scram device, so I know that you're not consuming alcohol. As it stands now, I'm revoking your bonds and I'm putting them both at $25,000. Do you understand? She goes with you.
Right here is where the judge drops the hammer. And honestly, you can feel the frustration. Harris County has one of the highest rates of alcohol-related fatalities in Texas. So when this defendant racks up a second DWI while already out on bond, it's not just reckless, it's dangerous to every driver on the road. Notice how the judge sets conditions that practically make it impossible to slip up again. No driving, GPS tracking, and even a scram alcohol monitor. That's a legal leash with no wiggle room. But let me ask you, do you think that's enough, or should she have been held without bond completely?
You now have picked up a new case, Mr. Arispe. You now stand charged with terroristic threat or a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officer was dispatched to a residence in response to a family disturbance. The complainant, the defendant's stepmother, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family, if they don't have my money by tonight, I'm going to kill them, as well as I'm going to send my people to shoot them up. The defendant also told the complainant directly, if you don't have my money by tonight, you are going to see. A family member of the defendant and complainant stated that he had seen the defendant walking around with a pistol in his pocket, and the complainant knows that the defendant owned several rifles as well.
You were on bond for unlawful carrying of a weapon. Did we order him not to have one?
Yes, Judge.
Regardless, you picked up a new case. What happens now is I'm going to revoke your bond in the first place and you will stay with me. I will appoint you a lawyer today, Mr. Ariste, so we can talk about how to go forward, but I am ordering you now not to have any contact with these people. Do you understand? And I'm going to tell you, you pick up a third case, I'm going to go bonkers on the bonds. Do you understand? I'm going to do everything in my power to protect this public at all cost. All right, goes with you. Do you mind appointing him? No? How are you? You know. Who do you want to talk about first?
Let's do Lestrade.
Okay, come up, Mr. Lestrade.
So Judge, there was misunderstanding on this case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received a letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrade, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens.
Okay, thank you.
Not once, but twice. What should I do now, Mr. Lestrade? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment. Has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
No, it's not. She at home.
Did you come with mom today?
No, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR moment. you know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond though, Judge? Because I believe the bond's at.
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
We're saying the bonds all in the
So this is Mr.
Yeah.
Worthy.
Mr. Worthy,
Yes, Your Honor.
you were placed on probation. You were on probation for unlawful carrying of a weapon. Now you've picked up a new case. So we are now filing a motion to revoke your probation and a warrant's going to issue. We will take you into custody now.
Because we would ask if we could set this for a hearing on the MAJ before we take him in custody.
Yeah, I mean, he picked up a new case. He's on probation. What we do is when any you pick up a new case, motion to revoke gets filed. That's the normal course of business. You're supposed to not pick up a new case, right? Okay, goes with you. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, there was, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas
Yes,
driver?
Judge, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to
I
address that.
wanted to.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the
Talk
lawyer.
about my two kids before that, sir.
I'm not going to talk to you about this. We'll put you in back. If you want, I can give you a new.
Think about this for a second. 106 miles per hour, weaving through heavy traffic with no headlights. That's not just reckless driving, that's practically turning your car into a weapon. And here's the kicker. The defendant already had 2 active bonds. This is why the judge doesn't even blink before revoking them. The court isn't just punishing the speeding, and it's protecting everyone else on that highway. I've got to ask you, should multiple offenders like this be allowed back on the street at all? Or should repeat dangerous drivers lose their freedom until trial?
Lawyer today. I'll give you a lawyer another. If you want to get off, and I'll provide you another lawyer. It's the 3rd case. Unacceptable. Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 18, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and
marijuana.
that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, you know? So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but you know, he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm going to do it at 5,001.
Okay. So first case, 5,001, and then the new case, of course,
I'll
would be
leave
bonded
the
out
first
as.
one or the second one as is, though. You now stand charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are in a dating relationship, and on January 25th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated that he and the defendant are dating and that they had recently gotten into an argument earlier that day. The complainant stated that he had thrown some nicotine cartridges on the floor and that the defendant and him got into a physical altercation but separated. The complainant then made food and brought the defendant a plate of food, but the defendant used it to strike the complainant in the face, causing a laceration above his eye. The complainant then stated that he began to fight back.
Same complaining witness in the terroristic threat?
No, sir, Your Honor, it's not.
No, Your Honor. It does appear that the complaining witness in the recent assault was a witness to the previous terroristic threat, but I'm still not sure the involvement so far.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
I ask you one thing. I ask you not to pick up any new cases. You have done, because you have done this now, I'm going to revoke your bond on your first case, and I'm going to put you in jail right now. Goes with you, officer.
Thank you, Your Honor.
Thank you, Mr. D. 5,001.
Here's a fascinating legal tug of war. The defense is arguing technicalities, smell of marijuana, type of smoke, airtight jars, but the judge isn't having it. Why? Because the standard at this stage is probable cause, not beyond a reasonable doubt. And when you stack the evidence, speeding, expired registration, cloud of smoke, plus baggies and scales, the judge's decision is practically inevitable. But let's zoom out. This isn't just about marijuana possession. This defendant had already promised the court he wouldn't drive. That broken promise sealed his fate more than any jar of weed ever could.
Sorry, bear with me a second, James. And you, please. Hey, Vic, are you ready to do Proctor real quick? Come up, Mr. Proctor. You are on bond for a terroristic threat, and now you've picked up a new case. You now stand charged with the offense of driving while intoxicated. First offense, it's over a .15, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Alex, do you mind? This is Proctor, please.
Yes, Judge.
The new case, the DWI.
On January 24th, 2025, the officer was dispatched to a vehicle accident on Conklin Lane, Harris County, Texas. The officer observed the defendant's vehicle stuck in grass, and the officer made contact with the defendant, the driver, and sole occupant. The defendant stated he was going fast and lost control because he hydroplaned. However, the officer observed no water or ice on the road. The officer observed glossy eyes in the defendant's one eye, slurred speech, and a strong odor of an alcoholic beverage. The defendant stated he was on his way home from NRG as he was at a rodeo event. The defendant stated he drank 2 beers and standard field sobriety tests were administered. HGN 3 out of 6, and the walking turn was unable to be performed due to equilibrium being off from the defendant only have one eye. The one leg stand was started, but the defendant stated he could not do the test 20 seconds as the test had already been started. The defendant read the DIC and consented a breath. The results were .161 and .155.
All right, Mr. Proctor, I'm going to find that there's probable cause to go forward with a new case. We have not addressed the old case, correct, Mr. Pons?
No, sir.
Okay. Because you're on bond, you picked up a new case. I'm now revoking your bond on the first case. Goes with you. The bond is set at 5,000 now, James. I usually, when it's, would you raise it up to 5,001 now because it's 5,000? I guess I'll do half and I'll do it 7,501.
Okay. I was hoping maybe on the probable cause issue first.
Oh, tell me if you have an argument. I'm all.
Well, it's got one eye, so the tests are off. So all you have is him just saying I had 2 beers as probable cause of intoxication.
But that's not. I mean, you take it as a totality. There's all the other.
Your Honor, respectively, they observed HGN in the one eye, the 3 out of 6, and that
I don't think you can do that.
Have the odor, and they still have his statement being that he drank 2 beers, and then also his refusal to do the test, and then as well as
You have an accident.
and the strong odor of an alcoholic beverage.
I mean, you have a breath test it's twice over the legal limit as well, allegedly. So, I mean, I think that there's enough to go forward for probable cause purposes. Beyond a reasonable doubt, I don't know, but I think there's enough. It goes with you.
Well, he's got one eye, so I got to at least try.
I got it. I understand.
Okay.
And look, I wouldn't take credence in that test anyways, I mean, even assuming it's done all correctly, what it's 77% chance as it is.
Gotcha.
Yeah, but taken together the totality of everything else, I think it's sufficient. So,
Okay. What about instead of revoking the bond? Because what we did last time with Judge Andrews was she kept the bonds the same, and we let him out, hoping that the conditions on the DWI would satisfy any threat to the community.
No, I want him to get it. He's not getting it, and so
Okay.
I mean, after, if he's unable to make bond, come back and we can talk. But not now.
Okay, so what was the new amounts now? Or the new amount?
7501 on the, I'll leave the DWI as is, but 7501 on the terroristic threat.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in County Court at Law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that. And we would ask that you would revoke the bond in this case.
Judge, this is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs, as with
Yes,
regard to
Your
this,
Honor.
not anything else.
Okay,
All-
well,
okay,
And we
go
would
ahead.
say that the defense also has the ability to subpoena as well.
And this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
But that's on them. If there's a problem with the machine, then it's on them to go have its service or whatnot. So
Does she know it's
all I
working?
know, it's, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior and I'm in effect telling you it's okay when it's not okay. You're skipping tests. It's a second offense. It's done. All right, I'm revoking her bond. She goes with you. It doesn't make me happy to do it, but I mean,
I
it's
understand.
bond violation after bond violation. I mean, all right, off the record. So she has the first violation, right? This is the second time we have a bond violation, right? And the first one, was it that she just didn't get the device, right?
Yes, that's when we were going back and forth on the dates to get it, and we kept resetting the case because she said that she was gonna get it and then she didn't, and then we were gonna revoke her, but then she didn't come to court, so then we sent her again, and then she didn't get the device that day, so then we gave her another chance.
Okay,
And
All right.
Judge, I don't think I represented Ms. Lynch the whole time on that, but I think some of the confusion was she was ordered to get the in-vehicle interlock and she didn't have a card.
but you did come at the time to where
Yes,
she
correct.
did get the device
And then
within,
once Ms. Lynch because I believe the vehicle was damaged in an accident and she was hoping to get the vehicle out and get it repaired. And when she realized that wasn't gonna be possible, she got the portable device.
My car's fixed now.
Yeah.
I started getting.
Okay, we'll get to that in a minute.
my concern is that it continues to happen. What am I supposed to do? The problem is if I let you go, I'm telling you the behavior is okay for you to do. It's not. We have court orders. You're supposed to follow court orders. You're doing what you want to do. That's not the way it works. Look, this isn't, I'll let you talk with your lawyer, but it's there. It's continuing to happen. You're skipping and you're continuing to consume alcohol. I'm sorry. I'm going to revoke your bond, man. She goes with you.
Judge, maybe go back and I'll talk to you.
Anything else?
Judge, since she does have a vehicle, if she makes the new bond, can we switch her from the portable to the in-vehicle?
Yeah.
Okay, thank you.
Mr. D.
Judge, I'm here on Mr. Edward Brandon, Burton. Edward Burton, he had gone yesterday, Your Honor, to take a drug test. It's my understanding from talking to pretrial services that, my client had tested positive for cocaine,
Come up, Mr. Burton.
methamphetamines, and marijuana.
We sent him for a drug test yesterday.
Bond violation for the.
He tested positive for methamphetamine, cocaine, and what else?
THC.
No, sorry, goes with you. No, sir, it's unacceptable. Can't be using. I'm not gonna talk to you. We'll let you talk to your lawyer and you tell me, but. Hi,
Good morning,
Ben.
Your Honor.
I wish it was always under better circumstances. Shh, you know,
I had an opportunity, I'm here on, Mr. Caleb Jones, judge, took a look at the bond violation report here.
I haven't even seen it. All I know is that we have another bond violation.
Well, I've had a chance to discuss it and help break it down, make it as digestible as possible, Judge. Essentially, we have some minor GPS violations, a 20-minute exit during curfew about 10 o'clock, and 2 late arrivals, 10:06. And 1 positive BAC.
There were.
Come up, Mr. Jones.
Multiple IVs, they're on the report that was sent
I looked at
for the first, second, and third.
Yes, Judge, and those reports being referenced there were follow-up lows that showed a declining level on those, unless I'm mistaken.
They go down and then they go up again on the.
Doesn't matter. It's no tolerance. We've been through this over and over and over. At what point do you get it, Mr. Jones? This is, how many bond violations do we have here now?
I believe this will be the third.
No.
Last time, I believe, Judge. That's why I said 7502.
Because I was generous with the 2 portion, but it's not just 2, Ben. We've had probably 5 or 6 bond violations. All I know is that you are testing positive. You're in violation of your curfew again. What am I supposed to do? Just continue to let you go?
No, I understand that, Your Honor, but I don't know what I can say about the breathalyzer, sir, because I don't drink. I don't drink at all. I don't know why that the thing was doing that. I had to go back to the Smart Start place the next day, and because they have those little tubes that stick out of it. But I don't know. I mean, if you look at the test, you can see that I haven't failed any of my other breathalyzers, and even some of the breathalyzers will say like 1 minute it's failed, and the next minute it's like lower and then higher, and I don't know. But all I know.
Have a confirmation of alcohol, Felicia?
From the portable device records, yes, they were provided to everybody in the email.
Judge, I'd have an opportunity to look at those, just to clarify, in regards to that, there are other instances where we do have BAC readings, Judge, and there are follow-up blows that
They're
show.
not confirmed as alcohol consumption.
And they will say, not confirmed, but we have some that are confirmed. He's blowing on his, or he's not in.
There was not a follow-up test on this positive, Judge.
No, I'm revoking your bond, Mr. Jones. It can't continue. No, goes with you.
I don't know what I can tell you, Your Honor. I'm not drinking or doing anything. Like,
I have evidence that shows me otherwise. And it's over and it's over and it's over and it's over.
Can't we
This
put
is
me
a
on, like,
4th,
the-
5th violation that we have, Mr. Jones.
why can't we put me on like the ankle monitor drug thing or something like that so I could prove to you that I'm not.
We had that.
I
We
never
took
had
it
that.
off.
No, I was never on that, Your Honor. I was.
Judge, if the court would consider
No.
additional conditions, Judge.
I have done everything in my power not to put him into custody. I have let him go over and over and over every time. And I'm done with it. I'm done with it. Something is going in your body that's causing it to test positive for alcohol. He goes with you. That's it. I told you last time, it's no tolerance. You're blowing your GPS, the curfew anyways. Goes with you. Mr. Martinez, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have a bond violation report where it's alleged that you have consumed alcohol when we have ordered you not. No, that if I will put you in a, do you understand? If you are unable to stop, I am giving you the opportunity now. If you are not able to do it, we are going to do it my way. And I promise you, you're not going to like the way that I do it. On this probation, if you do not have a license, you are not allowed to drive. If I find that you drive, you're looking at up to a year in jail. I will issue a warrant for your arrest. I'm going to put you in jail and I'm going to have a hearing. And if they prove to me that you violate any of these conditions, you are looking at an entire year in custody. Not only that, but if you are not in this country with permission and you go to jail and you do anything more than 4 to 5, 6 hours, immigration sweeps it on a daily basis. You already know what the administration is doing to undocumented persons. So if you're not here, you best be on living with a halo above your head. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement with me today, you either complete it successfully and you go on your merry way, or you violate this, we issue a warrant and you're looking at up to a year in jail. Do you understand?
Yes, Your Honor.
It is a 1-year jail sentence. I will probate it for 2 years. For you to successfully complete this thing, you must do a TRAS, which is an evaluation to see what conditions you may need. This doesn't say DW education class. I'm assuming it's supposed to be a DW education class,
Yes,
right?
Judge, it's supposed to be a DW class.
This needs to be refiled.
We'll refile it, Judge.
Are you wanting a victim impact panel?
Yes, Judge, we'll refile it today.
None of that is on here.
I think what happened was Bernadette was here and she had looked at everything. And they said that because there's going to be whatever the TRS conditions are, I think she actually had Kelsey remove those. Is that right, Bernadette?
So record, yes, sir. I'm gonna just have it as written in a note, but we can put it on the.
Wait, is this a second or something?
Yes.
No, it's not a second. He has a pending one out of Tarrant County. That was in 2019. He was placed.
That's an open DWI right now?
Not anymore. He is on a deferred adjudication for 22 months out of Tarrant County. He started on January 6th last month. So he had 2 firsts is what's going on. And that's why after talking to Bernadette, that's why we did 24
And
months.
he's testing positive for alcohol now?
Yes, Judge, that's why we put it on the strand, having the first in Harris County was because of the open one. Or the previously open case, is why we got the device.
He tested positive for alcohol at 1:45 in the morning.
Should I anticipate the TRS recommending serve report?
Oh. This is a second bond violation report.
And that's why it's
It's a
2
second
year.
bond violation. He has an open DWI in another county, and now he's consuming alcohol.
Judge, the first one was from 2019 and he didn't have court until they didn't realize or didn't come to anyone's attention until he got this one. Then the officer told him, you have something open in Tarrant County, you may want to contact them. That's when he contacted them and then he told them, yeah, come to court for that. So it kind of fell by the wayside. I don't know what happened.
Sit for something. You get about a list of documents this high from lawyers advertising to you that you have an open case. I have to imagine that he knew about the open DWI in Tarrant County. Now he picks up another DWI. Now we're on a second bond violation report.
He's on probation over there now, Judge, and he'd be on a 2-year probation here.
No, this is not a good deal, man. I think that we're setting him up.
I think once he does the TRAS and if they recommend serve report, which they most likely will, I think he'll be getting the help that he needs. I mean, he's 25 years old. So he understands that he'll have to.
I think that I would prefer to do it first, you know?
What do you mean?
Do the TRAS first so we know exactly what, because I mean, I would require, because of the nature, going to do a repeat offender DWI education class, number one. I had no idea that he has an open one. Now he's got 2 BVRs. I don't think I'm ready to do this today.
Okay.
Not only that, you're on your second bond violation. You're continuing to consume alcohol and you have an open DWI in another county. It's unacceptable.
Well, that one's closed now, Judge. He's on probation.
I understand.
He's on probation.
He's on probation. I mean, he's had it open. He's now on probation. And he's, a week ago, he's consuming alcohol still.
Right.
I let him do it once. I can't do it again, man.
Judge.
I understand that you have to zealously advocate for your client, but it's time. No.
What he was telling me was, and he showed me the paperwork, that the day after the alleged violations, when he was reporting to his probation officer, he doesn't understand how he would have tested positive when they would have tested him the next day. In fact, he actually got tested recently for drug testing. So they're drug testing him there and for alcohol. So I'm just letting you know what.
He's still, I have a scram. He's still testing positive for alcohol. It's unacceptable what's going on with you, Mr. Martinez. No, I'm not ready to take this deal now. And I think that it's.
Judge, my only concern is if he goes in, as you know, with this administration, he's not coming out.
Consequences, man. Actions have consequences, Mr. Martinez. You know that. You continue to do whatever you want to do. You continue to consume alcohol. You continue to put other lives in danger. It's unacceptable. I'm sorry, Marcos.
I'm trying to.
I know you are, but there's 2 open DWIs. He's on a second bond violation. It's not fair that I don't hold him accountable like I do every single other person here. I can't curry favor just because he may be undocumented. It's not fair,
I understand.
Yeah, I'm revoking your bond, dude. You're going to jail.
But if he's gonna be evaluated, and most likely he'll get treatment, which is what he needs. Putting him in custody, he's not gonna get the treatment.
No matter what we're doing, no matter what conditions I have bent over backwards not to put you in jail. You literally had another DWI open, did not put you in jail. You have 1 bond violation report. I did not put you in custody. Now you have a second. It's now time to pay. I can't let you go again because I need you to understand that we mean business and you're not getting it. Even that you're on probation, you have an open DWI here. You still consuming alcohol. I'm sorry, Marcos. You're going to jail. It goes with you. Marcus, it doesn't make me happy, dude.
I understand.
But
Get it.
that's it.
Pero ¿cuándo era? Vamos atrás.
So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in the back in the witness room.
Who is the complaining
So
witness?
my understanding is that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 8/10 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and His wife is here in court. Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. You know, when you have actions, you take the wrong action. There are no mistakes in life. They're actions. And when you take the wrong actions, there's serious consequences. I'm now revoking your bond on the harassment case. You're staying with me. You know, now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still want to go to rehab?
Then we'll talk about that.
We'll work through all the, I guess, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence. And the way that I do that are with these devices, you know, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? Okay, argument.
So Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a sparing device and for refraining from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be depended on.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you. Come up. Deputy Miranda, I'm going to need your help. Gomez. So Felicia, what did Mr. Gomez test positive for?
Judge, the results came back presumptively for THC and cocaine.
Unacceptable. I am now, you have a bond violation for tampering with your device. I now send you for a drug test. You test positive for cocaine and THC? Nope. Goes with you.
Judge, if I may, may I make some argument, Judge? Okay. Judge, so he is a plumber. Part of his duties as a plumber is sometimes he has to work in water. Because he has a device, he has to wear long rubber boots. The day of the tamper was a Tuesday, and it was during work hours. The time of the tamper, the alleged tamper was during work hours. He claims that he received notifications that the battery wasn't working, and he took it to Sentinel and Sentinel replaced it. We tried to verify that. We were not able to verify that with Sentinel. However, despite that, I believe that maybe those rubber boots that he had to wear that day because he was submerged in water at that point, probably had something to do with the device not reading appropriately. I mean, they're big, thick rubber boots that are waterproof. In addition to that, Judge, he is a father. He has a 1 year old, 1 year, 4 month old, and the mother of the child that are dependent on him. He is the primary provider for the family. I've admonished him that he is not to do anything, no drugs, no alcohol, no nothing, can't mess with his device. If anything ever comes up again with his device where he has to go in, he needs to notify me. So Judge, we're just be asking for him not to be revoked at this time and give him another opportunity. If the court would like to.
I'm not going to do it, Ray. He's testing positive for cocaine. I've ordered him not to use at all. I'm sorry. No.
If the court would like to do random UAs instead, Your Honor?
Or is this what we're doing now? It goes with you. Your bond is revoked. Sorry, Ray. I can't. I mean, I was prepared to do that with that, but you're testing positive for cocaine. Unacceptable. I can't just let you go with that.
Yes,
no, because then I become the enabler and I'm telling you, hey, man, it's okay for you to use. And it's not. No. I love you, Ray, but.
He's just going to get a nice hold.
Well, I don't know that, but hey, this is a second DWI. You already have a bond violation and now you're using? I mean, I can't just continue. I get it. He has to understand that actions have consequences. This is not our first rodeo. It's a second DWI and he's using?
Yes.
Sorry. Okay. 5,000.
I'm signing on to his new case.
Oh, he picked up a new case.
He did, Judge.
Mr. Palacio, you're now charged with the new case. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes. On February 5th, 2025, the officer was dispatched to a stranded vehicle at the 700 block of North Sam Houston Parkway, and the officer observed a car parked on the shoulder and a driver asleep at the wheel with the engine running and the car in park. The officer knocked on the window to wake up the driver, who woke up and refused to comply with the officer's command and drove the car 6 feet forward. The officer then requested the defendant exit the vehicle. The defendant put the vehicle in park, then drive multiple times before finally exiting the vehicle. The defendant was detained upon exiting the vehicle, and the officer relocated to a gas station where the defendant was observed to be dazed and confused and did not realize he had been asleep at the wheel. The defendant was also unable to communicate where he had been or where he was going. The defendant was asked to perform standard field sobriety test, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand, 1 out of 4. The defendant was read the DIC and declined to provide a sample. A blood search warrant was signed and executed.
I'm going to find that there's probable cause to go forward with the case. Can you look to see if he has any prior DWIs and does he have a valid Texas driver license?
He does have a valid driver's license, Judge, and we
Oh.
did file for the ALR hearing.
And then I see he has a dismissed DWI out of Fort Bend, but no other DWIs.
There's no probable cause in that case.
I'm now ordering you, well, the first thing I'm going to do is I ordered you on your first case not to consume alcohol or illegal drugs. You've now picked up a DWI. Guess what happens now? I'm revoking your bond.
Judge, I would like to address that. So he does realize that this is a problem at this point, and he has enrolled himself in IOP and does have a meeting this afternoon to do intake for IOP, and I do have that email.
I can't show him preferential treatment. It's on any case here. I ordered not to do something. He did it, picked up a new case. You're staying with me. And I'm going to tell you now, if I find that you consume alcohol again, I will put you in a rehab facility myself in the jail. And if you respond well to treatment, it's a minimum of 9 months. Do you understand?
Yes, sir.
I'm now placing a restriction that you're not to drive any vehicle that doesn't have a guardian interlock on it. You're not to consume alcohol, illegal drugs, and Casey, I'm now going to probably give him a curfew. In the BMV, was he out in the middle of the night? Alex?
Yes, Your Honor.
I think it was after a bar closed. He was just sleeping in the owner's vehicle.
There's one consistent problem, and there's one thing that centers around every single problem that you have. What is that one problem? Right. You and alcohol do not mix. And I don't know what we need to do to get you to realize that, but I don't know. I hope that this is it. If it's not, it's going to be a rather lengthy. Maybe that's it. Is it prison? I don't know. But all of the issues center around one thing. And I hope that you now realize this and do what you need to do. Because if you can't take care of it yourself, I will do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Okay, it goes with you. You were on bond for a theft case, and now you picked up another theft case. You now stand charged yet again with another theft. You're facing another 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, the complainant observed the defendant trying on sunglasses in their store in the Galleria Mall. And after the defendant left the store, the complainant noticed the sunglasses were missing. The complainant then reviewed surveillance in which he was able to see the defendant putting the sunglasses in his front right pocket and leaving the store passing all points of sale. The complainant then flagged down an officer who was able to locate and detain the defendant. The defendant was wearing the sunglasses on his face and admitted to concealing them. The sunglasses were valued at $350.
Mr. Taylor, I'm going to find that there's probable cause to go forward with your case. I am now revoking your bond on the first case. Goes with you. Unacceptable. We will not continue to give you PR bonds. This is your third one. No more. I will appoint you a lawyer today, but you're staying with me. I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it was low and then it went dead for, I think, a couple of days, but he didn't receive, well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
That doesn't give you the justification to do what you're doing.
Judge, I will say that I've contacted the device people over at 49, whenever he reported yesterday. They stated
He only reported yesterday?
Yes. We observed.
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of how long was the battery dead?
According to the viewer, I believe it started on the 10th, and then whenever he reported for.
Yes, Judge, that's what I'm saying.
Reported for inspection, we found no issues with the device itself or the charger.
Revoking your bond. You go to jail. I'm sorry. Bond, it's just bond conditions. There's no justification, right? 3 open cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
Judge, it went dead on the 10th, and he immediately went in to go have it checked out because
No, he didn't. No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead. So I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I understand that, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in.
That's.
And he was tired.
It's been dead for 2 days.
It's only been dead for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the 13th.
14th, I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Just not getting it. I don't know what to tell you, Ms. Jewett, right? There's just no justification. I have 4 kids. It'll take me 2 minutes to put them in front of an iPad for me to go do what I need to do, to go wash the dishes, to go take the dog out, to change the litter.
Well, I understand, Judge, but I mean,
there's no excuse. You've got 3 open, very serious cases. And I told him at the outset when you picked up the last violation of protective order, there's no talk. I mean, you must comply strictly. And he's just not doing it.
Judge, so it sounds like she missed her blows when she was working. She's clean. I don't know if we can go do a test today to prove that. I did notice that we're set for jury trial on the 25th. The only issue I have with that is I didn't realize that I'm set for an ag assault out of Orange on the 24th. So I would be asking for a reset of that jury trial date. As far as the bond violations today, I've explained to her the importance of.
No, we've done this before. This is our third time being back. It's unacceptable. I can't just let her go. Then I become an enabler and I'm telling her it's okay for you to do whatever you want to do. And it's not. You know, if you have an issue, you come up to here, you tell us what it is, and then we can resolve an issue. But I can't just let her go when it's a third violation. No, you're skipping test after test after test after test. This is your third time back on bond violations. It's unacceptable. No. She goes with you. Sorry. You're skipping tons of tests. It's your third time coming back for bond violations. Unacceptable.
Please, my son's graduation is coming. My son's graduation is coming. Please,
I'm not going to talk to you without your lawyer. Hi, Greg.
Hey,
What's up, man?
got a BVR on Mr. Galindo. He is present today. Younger kid, but dirty UA. That's what I'm being told.
Come up, Mr. Galindo.
It's not a EBR, Judge. We did a 45, it's been about 50 days, but originally 45-day reset for re-drug test because of the positive case results on December 31st.
Oh, okay, so hold on a second. Hold on. Mr. Galindo, you were charged with evading arrest or detention. You were ordered not to use alcohol or marijuana. We tested you in December. You tested positive. I told you not to use anymore. Did he get tested today?
His mom is here, Your Honor, with him, just so you know.
Okay, where's mom?
Mom's in the corner.
Come up, mom. Do you speak English, ma'am?
Yes.
Thank you so much for coming. So you familiar with what's going on? So he's charged with a serious case. I told him not to smoke or use any alcohol, use marijuana. We tested him in December. He tested positive. I've tested him now. We are roughly almost 3 months later, and he tested positive again.
THC judge one more time.
Same thing. Sorry, bud. Goes with you. I told you not to use. That's it.
Talk to you.
I got to show you that we're serious. I'm sorry, man. Yeah, 5,001.
Can I ask what the bond is, Your Honor?
Yeah, 5,001.
5,001?
No, you're not to use. I hope now we get your attention, but I don't know what else we can do. Okay, sorry. Goes with you. Okay.
Thank you.
Hi. Of course. Good morning, Mr. Garris. Great to see you, man.
You know, it's interesting. Every time I come in, your beard is either growing out or mine's
Right.
disappearing. So, but
Matching.
good to see you, Judge.
Twinkies.
Approaching on the Matthew Gomez case, and Judge, he's here and it's on your bond docket, but there's a BVR issue. I've talked with the state about it. Talk to them about what I think are some interesting issues, kind of by way of background in our case. And the state had previously offered, though we had not yet gotten the contract, to do a 90-day mental health PTI, which we felt was appropriate. They're going to review with the felony court to determine whether they still believe that may be appropriate, but they can't do that at the moment. They're going to have to get some feedback and find out a little bit more information about the new felony charge. I read the cases and think there's issues with both of the cases. But there is the pending BVR based on having picked up the new felony charge and need to.
Is he here?
Yes, he's here.
Come up.
Yeah, call him up.
Please.
And it's not really our issue to delve into, but I think there's issues with the way the police officers maybe made the stop in the new case. And
If he's picked up a felony offense, I'm very upset.
we understand. And
Let me express my disappointment with you, Mr. Gomez. You picked up a felony assault of a peace officer while you're on bond for this case. What happened, please?
So in the felony, the officer dispatched to a suspicious person call at a close gas station They observed the defendant walking around the vacant lot holding 2 glass bottles of Corona beer, indicating possible intoxication. They attempted to stop and identify the defendant, but he ignored commands and walked away towards the main road. And despite multiple warnings, he refused to comply, and he threw a glass bottle at an officer before fleeing on foot. Officers pursued the defendant for half a mile before detaining him, and while being transferred between patrol units, the defendant had already moved his hand restraints to the front of his body, and the officer attempted to reposition the restraints behind him. That's when the defendant pulled away and struck the officer's left thumb with his elbow, causing pain, redness, and tenderness. And then the defendant attempted to flee again, but was taken to the ground.
And I think there's issues with walking up and saying, we see someone and no more. Well,
It's
I know it's
not our case to litigate.
Well, I know.
All I know is that you've now picked up a felony case. Where'd you going? I got to take him.
Well, Judge, well, if we're going to be revoking him on that, then I do think it is our issue to delve into. And I think there's issues with the way he stopped. And, but if that's going to be the basis to revoke him, then this court doesn't. But the entirety of the information that the officers receive is based on what I would contend is an illegal stop. You can't just walk up and say, without more, there's no
Go
reason.
up to a guy and say, hey, let's talk.
No, that's not what they said. They said, walked up and said, show me your ID. And that's an illegal detention. That is a detention, and it's one that's unlawful under the circumstances.
I don't know.
Well, I'd like to set it for a hearing if we're going to do that. And he posted bond, $10,000 in the felony case. We think that's sufficient to ensure that he appears for a hearing, a formal hearing on it, without needing to take him into custody. I've talked with his mother. His mother has had good contact with me throughout this process, and she'll ensure that he's here. I think if we set it for early next week, then we can delve more into the felony case and figure out if the mental health, and I think the state can get an answer about whether mental health treatment is what's appropriate. We think it's appropriate, and even if you delve into the background of our case, the allegation is that he called the police himself and said, hey, I've got traffic tickets, come arrest me, come to my home and arrest me. An allegation, well, and that he also said, and when you get here, I'd like to be in a fight. And when the cops arrive, they oblige him, they put their tasers away and fight him. And that's consensual conduct. And whether we like it or not, humans have the ability to consent in physical fights if they like in Texas. And it may not be something that we would do or agree with, but legally people are entitled to do that. And so he's not resisting arrest even in our case. So we think there's issues in our case, but we thought on the defense side that it may be more appropriate to go the Harris Center route and see if mental health PTI.
I appreciate your argument.
Yes.
I appreciate your tenacity, but I have to be fair to every single person that comes through here.
Mm-hmm.
We have certain standards and procedures that we follow.
Sure.
When anyone picks up a felony case, especially a violent felony case, we revoke the bond and we put them in custody. We cannot continue to act in this manner. We are a civilized society and actions have consequences. I'm happy to give you a hearing, but no, I'm taking you into custody. You picked up a felony assault of a peace officer.
Judge, and my position respectfully is if he's entitled to, Judge, before he be taken away, we finish this portion of the hearing. I think he's entitled to be present at that. But we think it also a part of due process that before a revocation occur, that you're entitled to both notice and an opportunity to be heard. And if they're going to be seeking to revoke his bond, then under our rules of evidence, it's very clear in Rules of Evidence 101 that a revocation, the rules of evidence apply. And everything that's gone on this morning is a proffer by the state, and I respect the proffer, but that doesn't meet the standard for the rules of evidence, and that's why
The judge found that there was enough probable cause for a felony office to be filed against him.
Sure.
I don't want to relitigate a felony case here in misdemeanor court.
And I think that's fine. Well, but I think we're entitled to if we're going to be, and that's what the hearing would be for. But that
One of the conditions of his bond is not to pick up any new cases. He's picked up a new case.
And as an evidentiary matter, there's been no presentation that he violated the conditions of bond. I know that you can look in your system and even take judicial notice of that court's finding, but that finding and pleadings that charging him with a new crime, those are not self-proving. And if they're not self-proving, then there's no actual evidence that's been presented. And we'd be entitled to ask questions to prove up, for instance, that they illegally stopped him. There's no basis for that detention. And so respectfully, I'd like to set it
Not
for,
going to relitigate the felony case. I'm not going to. You know, I respect your position, but I'm not going to.
well,
He violated a condition of his bond.
says who?
Says a felony court magistrate that put on the case again, that
He's entitled
filed
to be
it.
heard on that. And
He did in felony court.
I don't believe that that's,
He goes in front of a magistrate. He has a defense lawyer in the magistrate, you know, when they do the magistration. So he does.
well, I think he's entitled to be heard here. If you're going to revoke his bond, I think he's entitled to be heard here. And that hasn't happened. And it certainly hasn't happened in accordance with the rules of evidence.
Your Honor, I would just say that, just reiterate that a district court has found probable cause in this case. To say there's no evidence that he violated a condition of bond is flat out wrong, because a district court judge has found probable cause on this new bond. She is picked up.
And that's not self-proving. Otherwise, in trial, they could just come in and bring in that piece of paper that finds probable cause and submit that as evidence, and they can't. That's not evidence. Those are not self-proving findings.
We're not in a trial here,
Well,
right?
Well,
You know?
no, I know it's
This is
not.
just, we're having a bond hearing.
Sure.
He's violated the condition of his bond. I understand that you don't like it. I
It's not that I
appreciate
don't
your
like it.
tenacity,
Disagree
but
with you.
okay, and reasonable minds can differ, but he's picked up a felony case and there's a certain process that we follow.
Well, and so we'd like a hearing on that.
Yes, I will give you a hearing. Yes, but I'm taking him into custody because he's revoked and he's a danger to the community. I find by clear and convincing evidence, he refuses to comply with his conditions of bond. Goes with you. You are on bond for a theft, and now you've picked up another theft and an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and put a speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale.
Hold on.
To purchase the item.
Oh, you didn't?
Yeah.
I was going to give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop. The officer was on scene when the complaining witness was attempting to stop the defendant. The officer told the defendant to stop running, and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the third floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129. And the defendant started to run from the complaining witness towards the nearby apartment.
Mr. Castillo, I'm going to find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, I'm now revoking your bond on your first case. You will now go into custody. I told you not to pick up any new cases. You've picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
Can you appoint him a lawyer, please? I will appoint you a lawyer now and we'll talk, but no, you can't continue. Unacceptable. You were on bond for theft.
Yes, sir.
And now you've picked up another. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
On February 17th, 2025, an officer was sitting in a Walmart parking lot and observed a male wearing a black jacket, red shirt, and brown pants running at a full sprint from the front of the store with what appeared to be a large box holding near his waist and trying to conceal with a jacket. The officer shouted to the male to stop running approximately 60 feet away. The defendant stopped, made eye contact with the officer, and entered the passenger side of a motor vehicle. The officer shouted for both occupants to stop, at which time the motor vehicle sped off, exiting the parking lot. The officer was advised by another officer that he was behind the motor vehicle at a Valero gas station parking lot. The defendant was detained and recognized as the same person observed to run away from the store. The complainant, a loss prevention associate, provided video showing the defendant walking past all points of sales with a speaker, total value $289, and the defendant was later ID'd by his Texas driver's license.
He's on bond for a prior assault.
For
Was it-
prior theft, yes. Judge.
Right. Was that at the Walmart? And did we order him not to go to a Walmart?
That prior theft was from a Home Depot, Judge.
I can't continue to give you PR bonds, Mr. Mary.
Yes, sir.
You continue to pick up cases. What am I supposed to?
I'm picking up.
Stop.
Yes.
I'm not asking you to talk. I'm just telling you, I'm not going to continue to give you PR bonds. You're going to stay with me. You picked up a bond while you're on bond. I told you not to pick up any more cases. You've now picked up another case.
Nobody told me anything. The first time was,
Stop. I'm revoking your bond. I'm putting you in jail now. I'm going to appoint your lawyer and we'll talk and we'll figure out where to go from here. But this is the third PR bond now. No, sir.
isn't that 3?
It's 3.
But it's not me though. I only have
This is not a negotiation right now. I will appoint your lawyer. I want you to talk to someone and then we'll figure out where we're going from here.
I spoke with her and she said it's okay for us to approach on that. So I apologize for that.
All right, Judge, and just to distinguish where we're at, this was not an alcohol event at all. He's been.
I don't know that. How do I know that?
It reads.
I know that, but what in these instances, what happens is someone puts something in between the leg and in between the device to be able to subvert any kind of reading. That's what happens. So when you see something where there's no contact with the skin for a certain period of time, here it's 2 days, there's no contact.
And that's exactly why we're here, Judge. And I showed the prosecutor his leg, and we've been having issues with his whole entire leg is completely chewed up because of this device. It is.
But the solution is you come to court, you say, hey, I need to switch it to another leg. You don't just on your own initiative start sticking a piece of paper or a towel or something in there, you know?
Judge, I get it. I mean, just there's a tamper event doesn't mean it was intentionally done. And he's on GPS and he's
There's
on.
no way for us to know.
I
All
agree.
I know is that it broke contact with the skin for 2 days.
I agree.
Come up. I appreciate your tenacity, Mr. Leeper, but he has a DWI. He's got an FSRA where we have a dead body. He's not one violation. We're now working on our second to third violation. And now you're putting something, or I don't even know, but all I know is that the device lost contact with your leg for 2 days. That is unacceptable. When you have issues with a monitor, you bring it to your lawyer's attention. You come to court and you say, look, this is what's happening. You don't put something in there in hopes that we're not going to notice. And now you tell your lawyer after the fact. I'm sorry, Mr. Lee, but what choice do I have but to revoke his bond again? You know, I know that it's upsetting, but no, I have a very serious case with you. You've been ordered not, you know that there is no tolerance in this case. Yet, you lost contact for 2 days. I'm revoking your bond. Go to jail. Sorry.
What's his bond?
Mr. Leeper, I mean, I don't know. Judge, you know, I'm not getting through.
Well, this is the other side of it too. He can't switch legs. He's got a GPS on his other one. You know, he should have, I agree with you, this court, I agree with it, but something's good. We're gonna have to change something or even move him to like a full-time portable blow. Because it's not an alcohol issue, Judge. And, you know, he obviously made the mistake.
I don't know that, right? Until you come here and tell me, I don't know. The only thing I know is we have a DWI, we've got an FSRA, we've got a dead body, and I've got multiple violations. And now you're hiding, you're doing something 2 days that I don't know about. You know what the proper procedure is when there's an issue. And you're just not doing it. You do what you want to do. That's not the way it works. And now you go to jail. Goes with you.